Okay, everyone. Well, look, thank you very much for logging in this morning, and welcome to the fourth of 5 Brexit webinars by us here at Burness Paull. And I hope you find this morning's webinar as informative as the others have been so far this week. My name's Ronnie Brown, and I'm the head of the tax team at Burness Paull, and consequently have had a fair bit to do on Brexit, as you might imagine. I'll be discussing VAT, import duties, and generally the situation as it applies to import and export from a tax perspective. I'm joined this morning by my colleagues Lynn Moss and David Goodbrand. Lynn will be having a look at trade deals such as they are at present. We'll look at licensing post 31 December, and also have a look at sanctions. David will be looking at Incoterms, looking at contracts generally and what may need to be done to contracts to make them sort of Brexit compliant. And we'll finish by having a look at the supply chain. Due to that action-packed programme, there will not be time for questions, but if you do have questions, please feel free to post them on the webinar or email them in, and we'll be delighted to pick those up with you afterwards. So just on a couple of housekeeping points, could I ask you all to ensure that your mute button is still on? It should have been automatically muted when you joined, but if you could just make sure that you keep it muted to prevent background noise while the speakers are on. We will be recording today's session, and that will be made available to you afterwards. And finally, there is no fire drill planned, so if you do hear the fire alarm, get the family and pets out of the house as quickly as possible. Okay, so without further ado, I will start on the tax implications of Brexit. And I suppose the opening comment I would make is clearly everyone is waiting to see whether we get a trade deal, and as each day passes, that looks less and less likely. But I think even if we do get a trade deal, it's unlikely to alter much of what will be spoken about this morning. The declarations that need to be made from a customs and VAT perspective are likely still to be required. And I think the most meaningful change, if we get a deal, will be that tariffs are likely to be removed. So the monetary pain of tariffs will go, but the compliance pain of declarations, etc., are likely still very much to remain in place. So starting with exports from the UK to the EU, I trust those amongst you who do so have all now got their EORI numbers, and certainly if you haven't, you pretty much should make sure you have for 1st January, because it will be vital going forward no matter what happens. And from a UK perspective, the VAT treatment of exports will be pretty much as before, namely they will be 0 rated in the UK. But the problem is the world of pain that awaits you if you are then responsible for the VAT in the EU. Now, of course, the way to get out of that would be to have your terms with your customer to be on a DAP as opposed to a DDP basis, where the customer will take responsibility for all the import VAT and import duties, but that may not be possible from a commercial perspective. The customer may insist on it being DDP terms rather than DAP, in which case the VAT and customs responsibilities will lie with you. So what options would you have in that situation? You could register in all of the EU countries that you supply, but if you're doing it to all 27, that will be a complete headache. And in many of those 27, there will be a requirement to have a fiscal representative as well as registration. They won't allow you to handle your own VAT. Potentially, you could register only in the countries where they're having the ports at which you are delivering your goods, and effectively be registered there. The problem with that is that if you have sort of mixed batches of goods that are going to various countries, that just doesn't really work. You could set up your own place in the EU, but there's wider tax issues and commercial issues there too. And similarly, if you were exporting to the EU, all the goods would need to go through that particular establishment. You wouldn't be allowed to supply directly to the customer. So there would be logistical headaches there as well. There is what's called Customs Procedure 42, which may assist if the goods that you're supplying to your customer are being onward supplied by them to another EU country. That procedure allows the import to be effectively exempted from VAT. But again, it's a pretty technical and difficult process, but may be worth looking at if all else fails. So that's export from the VAT side. Importing, probably less of a headache. Again, if you can have your supplier on DDP terms, then they would be responsible for all of the UK VAT and customs aspects of the import. The problem they face is that they would require to be UK VAT registered and would also have to have a UK customs broker. And I understand that customs brokers are a bit like hen's teeth at the moment, and you can't get one for love nor money. Consequently, it may be that you have the responsibility for the VAT and customs duties. In the context of VAT, however, the position really isn't that much different from present. At present, as you probably know, you work on a reverse charge basis, whereby you charge yourself input VAT and output VAT in the same VAT return. And that's the effect of the postponed VAT accounting system that's going to be introduced for imports into the UK. So you will now declare import VAT not at the point of entry, but in your normal VAT return, unless they are sort of specific goods which require upfront payment to be made. But in the normal course, you will treat them as effectively payable at the normal VAT quarter or VAT month that you do your returns. There are different rules for imports where the goods are worth less than £135, or it's an online marketplace, which effectively means that the importers of those goods would be responsible for paying the UK VAT at the point of sale. As far as customs duties are concerned, the joy of that is that there is a system called Chief with which you may be familiar, but that is supposedly getting superseded by a CDS system, which the government saw fit to introduce this year. However, to say that's had its teething problems is a gross understatement. And effectively, it doesn't appear to work. They've trialed it on a small random sample, but there's extreme reservations about it working on a larger scale. So customs declarations are still a bit of a mess, and certainly as a UK-based exporter or importer, I think you would really be very dependent upon your own customs broker or your logistics company, your freight forwarder, to see you through this difficult period. And again, in sort of part recognition of the mess that's there, there is the ability to defer customs declarations on imports and indeed to pay duty for a 6-month period, provided you meet certain qualifications. There is also the need to make security and safety declarations in respect of goods, but again, there is a 6-month deferral around those, again, to buy some more time after 1st January. Briefly, in relation to Northern Ireland, as you know, it will remain part of the EU for the purposes of imports and exports, while also being part of the UK, which is, as you'll have heard, a difficult balancing act to achieve. There was a view that goods being transferred to Northern Ireland from mainland GB would be treated as imports and exports. However, the UK government earlier this month came out and said that's not going to happen, and goods being transferred to Northern Ireland from mainland Great Britain will be treated in the same way as they are at present, as an intra-UK trade. Unless, again, there are certain special situations where you might, for example, onward supply those goods into the EU. So largely, it should still be business as usual for goods going into Northern Ireland, save only where a business is transferring its own goods across to Northern Ireland. And in that case, there will be the need to declare it effectively as an import into Northern Ireland, which should be VAT neutral, because there will be the ability to claim that VAT as input VAT and recover it. But it is, again, one more procedural headache. So that's a bit of a whistle-stop tour through VAT and customs duties. And I suppose the biggest concern that we all have is, even if you've got your AORI number, even if you've got your good freight forwarder in place, even if all your trade terms are outwards on DAP, inwards DDP, the problem will be getting the goods out or into the country, because I think there are major concerns around the actual logistics of it, and the ability of the UK customs teams to handle the volumes, such that there is a rumour that HMRC staff have all been told that they'll be leaving their offices or homes and moving to the ports at the beginning of January. So watch this space in relation to that. However, if I can now hand over to my colleague Lynn, who will take you through the licensing, trade deals and sanctions aspects of Brexit. Thank you very much.
Thanks, Ronnie. As Ronnie said, I'm going to talk about what the current position is in relation to trade, import, exports and sanctions, and what effect a no-deal Brexit could have on those. The trade talks between the UK and the EU, and between the UK and non-EU countries, have been coming to the forefront of the news again in the last few weeks. And whilst it's nice, although I don't think that's the right word to use, to hear about something other than COVID, with just over a month to go, there are fears that we just simply won't reach a deal, especially with the EU, in time. So where does that leave us, I guess, is what the big question is. In relation to the current position, as a member of the EU, the UK was automatically able to benefit from over 40 trade deals, which the EU had with over 70 countries. This meant that goods could move freely between the EU and those countries without customs charges or tariffs applying in most cases. After 31st December, these trade deals will no longer apply to the UK, and because of that, the UK is working to ensure that the effects of these trade deals continue to apply after the transition period ends. And so far, I think it's signed over 20. I think we're at 24 or 25 free trade agreements now, meaning that goods can, for the most part, move freely between the UK and those countries. There's been 2 quite significant trade deals reached recently with Japan and Canada, which have been on the news recently. And I think I saw on Twitter last night that we've just agreed a deal with Kenya. So things are happening, but whether they're happening quickly enough is of some concern. If we can't reach a deal with the EU, as well as other non-EU countries, then for export and sanctions and import purposes, the UK faces the prospect of World Trade Organization rules applying, which will mean that tariffs will be applied to most goods being sent from the EU, being sent to the EU from the UK. The UK could also choose to apply similar tariffs to goods arriving into the UK if it wanted to do that. So that's obviously will inevitably lead to increased costs for both businesses and consumers, and the talk of queues and delays at the UK border could become a reality. As Ronnie said, even if a deal is reached, it won't all be plain sailing, I don't think. One example of that is if you export food to the EU, that might still need to be checked at the border due to strict rules that are in place in relation to food arriving into the EU from non-EU countries. So it's things like that, which is why it's so important that businesses do what they can to prepare before the end of the transition period. As we are in the transition period at the moment, we're still able to move goods freely between the UK and EU member states. You don't need customs declarations and no import duty is payable on goods imported into the EU. In a no-deal scenario, we're likely to have no customs union and there would be a hard border between the UK and the EU. Customs declarations would be required, and that could affect all sorts of goods like animal products, plants, food, agriculture, medication and chemicals, and that could make international trade more expensive and increase costs for businesses. As Ronnie said, you will require an EORI number that starts with GB to import goods into the UK from the 1st of January, and you might also need to pay customs duties and VAT on your goods. There's also talk of a 6-month deferral on customs declarations, which Ronnie mentioned, but you do have to wonder if that's going to do more harm than good and just kick the problem down the road. In relation to export control generally, in a no-deal scenario, the UK would be treated as a third country, meaning that the rules for exporting from the UK into the EU will be the same as for exports to any other non-EU country. We've got quite an established regime for exporting strategic goods. So those are goods on the dual use list. So goods which can be used for both a civil or a military purpose. And for most of these goods at the moment, you don't need a separate licence to export to the EU from the UK. And so in a no-deal scenario, although the main regime wouldn't change, so the lists wouldn't change or anything like that, the licensing requirements would change. And you would need a licence for all UK to EU dual-use exports. To try to deal with that, the UK has created a new open general export licence, which is going to be known as the EU 27 OGEL, which is intended to mirror the current EU OGEL. Hopefully that will make the process slightly easier, but you will need to make sure that you comply with the conditions on the new UK licence, which might be different from the EU one that you're used to using. There are also some changes to the licensing requirements for non-EU exports of strategic goods as well. So if you already have a license to export strategic goods to a non-EU country, which has been issued by the UK authorities, then that will remain valid for export from the UK. Licenses issued by one of the 27 EU countries will no longer be valid for export from the UK to a non-EU country, and you'll need to apply for a new licence from the UK licensing authorities. If you want to export strategic items from elsewhere in the EU to a non-EU country, then you will need a licence from an EU member state before you can do so. In relation to military and trade controls, so that's the transit of goods between countries, those rules all originate in the UK and so won't change. So they'll stay exactly the same, as will the catch-all weapons of mass destruction end use rules as well. So they're going to remain as they are. In relation to sanctions, so these place restrictions on the movement of goods, provision of services, financial transactions, and immigration of certain people to specific countries. The UK takes its sanctions policy from the UN and the EU and adopts any UN sanctions policies into UK law. EU sanctions are directly applicable to the UK at the moment, but will stop being so at the end of the transition period. However, the UK government has said that it will continue to adopt any UN sanctions policies and will maintain all existing EU sanctions after the transition period. Whether the UK will adopt future EU sanctions remains to be seen, and that could mean that UK businesses which also trade in the EU and which are used to complying with one EU-wide sanctions regime could have to keep up with two separate regimes and comply with both UK and EU sanctions. So that'll add an additional administrative and compliance burden to businesses if that comes to fruition. In addition, because of Brexit, the UK now has the power to make its own policies and introduce its own sanctions. And it's already done that in July of this year when it introduced the global human rights sanctions regime. So in light of that, there could be separate lists. The UK could create its own list separate from the EU, which again will add an additional compliance burden to businesses which trade out of the UK and the EU. So that's really a very brief summary of where I see things sitting at the moment. In relation to things to consider and my top tips for making sure you're ready is if you haven't already, you should do a full audit of the goods and services that you currently import into the UK and export to the EU, as well as those that you send out with the EU. And I think if you've already done that, I would probably repeat that process now. And that will allow you to check whether you need any additional licenses and that your current licenses remain valid. If you rely on any licensing exemptions, make sure that you can still do that post-transition as well. I would recommend that you review your compliance procedures and internal processes and check that you can deal with any additional administrative burdens, such as applying for new licenses or checking different sanctions lists. And as Ronnie said, you consider whether you need to engage a broker or a freight forwarder to help with any admin if you haven't already got one. I think it's worth doing that. The impact that the changes could have on your business, as well as the potential penalties for failure to comply with export and sanctions rules, which include criminal fines, make it well worth your while to put in the work now to ensure that your business runs as smoothly as it can after 1st of January. And that's really all I've got to say on the export and sanctions. I will hand over to David now to talk about contractual terms.
Thanks, Lynn. We actually had a dedicated commercial contract session on Tuesday that dealt with a lot of contracting issues. So if you're not aware of that one, do check that out. So I'm not going to cover the same ground, but I think the reality is that most current trading contracts do not contain adequate provisions to deal with the potential adverse consequences of Brexit that we've been speaking about. So there are 3 points I was just going to try and cover briefly as we finish off here. The first is the Incoterms trap. What are they and what are the traps? The second point is supply chain risks. And the third is what does your contract say and what does it not say? So Incoterms trap. Ronnie mentioned a couple of instances of Incoterms earlier on. So Incoterms are standardized set of international trade terms that are published by the International Chamber of Commerce. And effectively, they provide a common set of rules and framework in which businesses can trade. So they define terms such as ex-works, EXW, free on board, FOB, or DDP, delivery duty paid. You may have heard of and you may have actually seen in your contractual paperwork. So they provide a shorthand way of addressing and codifying things like transferring of risk, where the location of delivery is, who's responsible for loading and offloading, who's responsible for carriage and the costs of carriage, and importantly here, who's responsible for export and import clearance. So if you are using Incoterms in your contracts or include references to them in any of your paperwork, such as purchase orders or quotes, etc., it's really important to know what these mean for you in your contracts, particularly in relation to things like delivery, import clearances, costs of carriage, etc. So are you using the right term for your business and for the right for the arrangement? And if you're not familiar with these terms and what they actually mean in practice for your contract, I think now's the time to have a look at them. The other thing we quite often see is Incoterms get used in conjunction with terms and conditions or other contracts. And quite often the Incoterm may be inconsistent with what the rest of the contract says, which leads to some ambiguity. So if you are using Incoterms as a shorthand way of saying what your contract is meant to be covering, make sure the rest of the contract is indeed consistent. Because at best we will have a conflict that needs to be resolved, and at worst you could find yourself in a long drawn out dispute with a counterparty and potentially the authorities, which may lead to increased cost, frustration and delay. So be careful using Incoterms. Supply chain risks. Most manufacturing and retail businesses will rely on supply chain, and these arrangements quite often need to work like clockwork to get the product to the end customer on time and on budget. And it seems simple to say that it would be beneficial to ensure that all these arrangements complement each other and support each other, but quite often they're not joined up. So it's helpful to look at your contractual arrangements and the risks and flows in those arrangements to make sure they are aligned, because I suppose otherwise there's a potential risk either that risks aren't left unaddressed, or else you find yourself piggy in the middle holding more risk than you would ordinarily want to take. So just have a look through your supply chain contracts to make sure that the risks aren't being adequately allocated. And the third point is, in relation to trading contracts, is have a look at what your contracts say, but just as important is what the contracts don't say. So what's not in the black and white page in front of you. If your contract's silent on key matters, it may lead to an inevitable issue in terms of trying to work out who's bearing the cost and risk. So things like governing law, it seems pretty obvious. You want to put a governing law to understand which courts will govern contracts, but quite often in heads of terms or trading arrangements or various other things that might be missing, so make sure that's included. We've heard a lot about standards and regulations and maybe the dual regimes that businesses will have to comply with. And I think it's probably fair to say that most contracts will not really take this into account just now in terms of EU regime and UK law going forward from 1st January, which applies, which was meant to apply, and what are the implications from that. So there's another thing to look out for. And finally, limits of liability. In this completely uncertain time where there is likely to be a lot of discussion between parties, shall we say, I think it's important to try and limit your liability in your trading arrangements as best you can, so that you're not exposing yourself and your business to unnecessary risk. So the key takeaway, I suppose, from my part of the session is to take the time now to review your contracts and your trading arrangements, because I think looking at them now, trying to get them in good shape for 1st January will save you a lot of time, effort and energy in the long run. Hand you back to Ronnie.
Thanks, David. And that effectively completes this morning's brief run through what are very complicated and otherwise lengthy topics, but I hope it's given you a taste of the issues that present themselves and was of interest to you. As I mentioned at the outset, this is the 4th of 5 webinars we're presenting this week. Tomorrow there will be a webinar covering regulations and standards, particularly changes in public procurement, environmental and consumer standards. If these issues would be of interest to you, we'd be delighted if you join our colleagues on that. Otherwise, that's it for this morning, and I wish you all a very good day. Thank you very much.